Well, welcome to today's educational webcast. Today, we're going to cover basics of estate planning, long-term care planning, and Medicaid. I will hand it over to a longtime professional friend and attorney, Andy Hochberg, and let Andy kind of take you through these basics.
Thank you, Dave. Welcome, everyone. We're going to talk about the basics of estate planning. We're going to get into a little long-term care and Medicaid planning as well. And just as an introduction, I'm an attorney in Newton. I've got a small practice. My focus is on estate planning, and we do a number of things in the office, but estate planning is my focus. So what I want to cover today in the next 20 or 25 minutes or so is, there's a lot of material. I'm going to kind of high level on some of this, and we'll get into the weeds on a few topics. But essentially, what I want to cover today is talking about what I call the tenets or the pillars of the estate plan. I want to talk about a will. What is a will? When do you need one? Why everyone should have one? We'll talk about the components of the will. We'll talk about a couple other documents as part of the pillars of the estate plan, including a trust. Revocable versus irrevocable. A lot of times people, question that, whether they should have an irrevocable or revocable and what's the difference. We'll spend most of our time talking about revocable trust, which is much more common than the irrevocable. We'll touch on estate taxes. There's some changes in the law, recent changes in the law in that area. And then the long-term care basics, and that's, kind of the nursing home, Medicaid type planning issues. Okay, let's jump right into the will. Okay, so we all know, sort of what a will is. If you don't have a detailed knowledge, a will is basically, it's a document that you put together. It's a legal document you put together, and it directs where your assets go when you pass away. Your assets meaning bank accounts, investment accounts, real estate, whatever you own when you pass away. The will is geared to direct where that goes. A lot of people ask is, if I don't have a will, does that mean I stay out of the probate court? Or if I do have a will, that means I stay out of the probate court? Kind of the answer to both of those is no, because if you have whether or not you have a will, whether you go through probate is a different issue. And by that, I mean, a probate is controlling the assets that you own in your own name when you die. And if you have a will, you control where those assets go. If you don't have a will, everything doesn't pass to the state, but there's a statute, it's called an intestate statute, that directs where your assets go. And it's generally, think of next of kin. So if you picture a family tree, you go up to parents, out to siblings, to cousins. Who's next in line? Who's the next of kin? Those are the people who are going to get your assets. But so the will, if I put the will in place, if I sign a will, when I sign it, I will get to decide where my assets go. So if I have, people in my family I want to take care of, or people in my family I want to exclude, these are provisions that I'll put in the will. And the will, when it comes down to it, as I said, controls assets that I own in my own name. So assets that are not otherwise disposed of properly. And by that, I mean, here's a couple examples on the slide here, and that is what assets the will does not control. So let's kind of define, what does the will control? Well, everything except that which isn't controlled by the will. All right, so let's go jointly held property. So jointly held property, I have a bank account. I own it jointly with my wife. When I die, it doesn't matter if I have a will or not. My wife is taking over that joint bank account. Likewise, if I put a child on the bank account. And just as an aside, something I would strongly recommend against putting a child or really someone other than a spouse on a bank account or investment account, with one exception. So if you have what people typically have, kind of the cash account, the family cash account, money goes in every month and you're paying bills out of that. I don't have a problem putting a child's name or someone else's name on that account. But if you have an account that you use as a savings vehicle, whether it's an investment account or a bank account, CD, don't put a child's name on that account, because now that account is subject or exposed to the child's creditors. Marital issues, car accident, just spendthrift issues from the child, now you're putting your money at risk. So stay away from that. All right, so that's kind of as an aside. The other type of asset or account that the will does not control are assets that have, or accounts that have beneficiary designations. So we know when we set up a retirement account, or for that matter, when we take out a life insurance policy, we have an ability to name a beneficiary. And whether or not I have a will, and no matter what that will says, the retirement account or the life insurance is going to that beneficiary. It's payable to the beneficiary at my death. One issue I want to bring up here is make sure if you have beneficiaries on your retirement accounts, for sure, make sure those beneficiary designations are current. So I've come across a few times where spouses will name each other as a beneficiary, and a spouse dies. The surviving spouse, if they don't go back and update the beneficiary designation or have a contingency built in, then that becomes a probate asset. So you think you're naming someone as a beneficiary and staying out of probate, but in fact, it comes back into the probate court. So when I set up my will, I'm directing where my assets go. I'm also going to put someone in charge of that. And that's person I'm putting in charge is called the executor or the personal representative. And those terms, think of those terms as being interchangeable. They're generally the equivalent, executor and personal representative. That's the person I'm putting in charge of my affairs when I pass away. That person is controlling the probate process. And by that, I mean, when I die, if I have an asset that's in my name only, no joint owner, and there's no beneficiary, that asset or that account needs to be managed through the probate system. So my executor will take the will and file it with the probate court. And essentially, they're asking the court to approve the will and to validate it. And when I write my will and I name someone as the executor of my estate, that really is just a nomination. The court needs to sign off and approve that nomination before it becomes official, before it becomes legal. So I'm naming the executor. The executor is controlling this whole probate process. The executor is going to implement my dispositive provisions, meaning they're going to distribute the assets where I want those assets to be distributed. My executor is also responsible for settling any claims. If I have, let's say I die and I have credit card debt, or I have medical bills, unreimbursed medical bills, it's my executor who's responsible for settling those, whether it's paying it off, questioning the legitimacy of a bill. So that's all on the executor's responsibility list. One thing I want to point out that the executor may be exposing him or herself to personal liability if they're paying something that shouldn't have been paid. I'll give you an example. So in Massachusetts, we have a very short statute of limitations or time period for anyone who has a claim to bring it forward when someone dies. So I die, I have credit card debt. The credit card company has a year to file a claim against my estate to get paid. But what happens if they don't do that? If they sleep on their rights, they come around in the 13th month. That window has closed. It's very short. If my executor goes ahead and writes a check to pay that bill off, the executor's likely exposing themselves to that payment because that was an improper use of money in my estate, and that should have gone to my heirs or my beneficiaries, not the credit card company. So the executor's job can be very important. It can be very time consuming, and it's not without risk. So the executor you want to make sure that you have someone you're very comfortable with and have complete confidence and trust in to name them the executor. One other element of a will that doesn't apply to everyone, but if you have children under the age of 18, you will want to name a guardian in your will. And the guardian is the person who's responsible for the care and custody of your child until he or she turns 18. And once the child turns 18, the guardian's job is done. It's finished. Okay? It just continues until the child turns 18. All right, so that's in a nutshell, or on a high level, what we would think about in terms of putting a will together. There are other documents that are very important as part of the estate plan that are called a pillar of the estate plan. The next document is going to be a power of attorney, a durable power of attorney. This is where you're appointing someone to make your financial decisions. And the power of attorney comes in two flavors. The first is, and it's less common, it's the immediate power of attorney. And the second is more common, it's called the springing power of attorney. So what's the difference between the two? The immediate power of attorney is as soon as I sign that document, it's effective. So I name my wife as my agent or my attorney in fact under my power of attorney, and it's immediate. She has the authority the minute I sign the document. The alternative is to, and this is more common, to have a springing power of attorney. It only becomes effective. I sign it today, but it only becomes effective when and if I become incapacitated. So if I name my wife as my agent under the power of attorney, and I have a retirement account, she's the beneficiary of the retirement account. But if I become incapacitated, no one is going to be able to access that money. Once she has the power of attorney in one hand and some authority, a letter from a doctor stating that I'm incapacitated, in the other hand, then she can access the retirement accounts. So it's a really important document to have, power of attorney. The next document is similar in how it's applied. It's a healthcare proxy. Similar to the power of attorney, it's giving someone the authority to make decisions. The difference here is this is any healthcare, medical related decisions is covered by the healthcare proxy. The trigger point is a little different. In the power of attorney, it's triggered by your incapacity. The healthcare proxy is triggered by your inability to communicate. So I may have all my marbles, but if I can't communicate, the healthcare proxy is implicated at that point. And oftentimes when you put a healthcare proxy together, you want to put a living will as part of that. And that's the discussion, the end of life discussion. If I'm ever at a point where I'm in a permanent, persistent vegetative state, I don't want to be kept alive by heroic measures. That's the living will. So we talked about a will, talked about a power of attorney, and a healthcare proxy. The last document that I'd call the kind of the pillar of the estate plan is the trust. And what is a trust? And trust is basically, it's an agreement that you're making with three people involved with this agreement, or three jobs. Could be one person filling three jobs. The first job is the grantor, the person who's setting the trust up. It's my money, I'm setting up the trust. I'm the grantor. The second job is the trustee. This is the person who's responsible for managing the trust assets. And the third is the beneficiary. This is the person for whom the trust assets are being managed. So a trust is not a type of investment. It's not a different mutual fund. It's the label that you put on your investment. It's the ownership of the account. It's appropriate for real estate. It's appropriate for bank accounts, investment accounts, mostly not appropriate for retirement accounts. So I set up a trust. We're going to focus on revocable trust. So it's a revocable trust. I am sitting in the seat of all three of those jobs, the settlor, the grantor, the trustee, and the beneficiary. So I'm setting the trust up. I get to decide in the trust where my assets go when I die. So isn't that like a will? Why would I have a trust if I have a will? Well, a trust does what a will does, kind of in a parallel track to the probate court, except the will is taking us through probate. The trust is keeping us out of probate. So one of the reasons why people set up trusts, revocable trusts, is to avoid probate. So if I own a home, it's in my own name, I pass away, that home now is going to be probated. On the other hand, while I'm alive, if I transfer the house to a trust, a revocable trust, I can still live there. It's still my house. But when I die, the trust controls where the house goes, not the probate process. All right. So I set up a trust to avoid probate. I can also reduce or eliminate taxes. And really what I'm referring to here is estate taxes. I'll get to that in a couple of minutes, but there are state tax exemptions that if I use a trust, I can better utilize those exemptions. I can also protect assets from creditors. And I say from my creditors and beneficiaries' creditors, but it's really the beneficiaries, because if it's a revocable trust, I am not getting any asset protection at all. If I put my house in a revocable trust and I hit someone with my car and they sue me, the house is no more protected than it was before the trust. No less protected, but no more protected. What I really want to focus in on is the protection of the beneficiaries. I leave my assets to my 28-year-old son, and he's got spendthrift issues, and there are always creditors looking to chase him down. Well, when I set the trust up, I'm not leaving him an inheritance in a lump sum. I'm putting rules in place that will protect the assets. He will have to go to the trustee to get a distribution. So that's how I can protect him. If I set up a trust, I can also maintain privacy. So one thing, when you file a probate proceeding, everything you have is out there. It's all public information, public documents. If I set up a trust and my assets are being disposed of or distributed through a trust vehicle, that's not a published document. So there's some privacy. Some people that's important, some people not so much. I get to control the assets a little better. So for example, I have my son, I want to control how he gets his inheritance and when he gets it. And I want to put someone in charge. That person I'm putting in charge is the trustee. It's the successor trustee, because while I'm alive, I am the trustee of my revocable trust. When I die, the successor trustee will step up to the plate. And this is different. This is not a revocable trust. It would be an irrevocable trust. We use trust to protect our assets if we're going into a nursing home for Medicaid purposes. And I'll get to that in a couple minutes. And the final reason to set up a trust is if I have someone, a beneficiary, a child perhaps, who has special needs. They're eligible for government programs that are based on his assets or lack of assets. So it's a needs-based program. If I leave an inheritance in a lump sum, I may be, and probably will be, jeopardizing the benefits on the government program. But if I set up what's called a special needs or supplemental needs trust, the assets, the inheritance, can be left in a trust, not disrupting the government benefits, and he can still benefit from the assets sitting in that special needs trust. Let's shift gears for a minute, talk about estate taxes. So there is a tax that applies when you die based on the value of assets that you leave. There are two taxes, and these numbers have changed significantly in the past couple years. The federal estate tax, the exemption is $13.6 million. And what that means is if the tax only applies if you're fortunate enough to have more than $13.6 million. The tax rate's very high, but the threshold is very high too. The state, it's a high threshold, but lower than the feds. It's a $2 million threshold in Massachusetts. And what that means is that the exemption is a true exemption. The tax, if it applies, only taxes the excess over $2 million. So if you have over $2 million, the tax rate starts at 1%, goes up to 16%. And the first $2 million is tax exempt, or exempt from estate taxes. All right, enough about estate taxes. Let's shift gears again and talk about a very important topic, and then Medicaid planning. So the basics of Medicaid planning, this is where you are you're in or thinking that you may end up in a nursing home, a skilled nursing facility, and you want to protect your assets for the kids perhaps, and you want to qualify yourself for Medicaid. So Medicaid is the program that pays for long-term care for folks who can't afford it themselves. So when I say can't afford it, it means they have no money. In Massachusetts, you're essentially allowed to keep $2,000. If you're a couple, it's $3,000. And if you have more than that, you're not going to qualify for Medicaid. So with that background, what can we do to protect our assets and qualify our assets for Medicaid? Well, one thing is to give assets away. And years ago, it used to be really simple. Mom went into the nursing home on Monday. She gave all of the assets away on Tuesday to the kids. And then on Wednesday, she qualifies for Medicaid. She fills out the application. Boom, that's it. Doesn't work like that anymore. Now, if you go into the nursing home Monday, you give the assets away on Tuesday, you got to wait 5 years before you qualify for Medicaid. As long as 5 years, it could be a little less. It's $410 a day that you're disqualifying. It's one day for every $410 that you give away. So what do you do with that background and that information? One of the things that you can do is set up a trust, and you can start the 5 year clock running. So when you set up a trust, a Medicaid trust, there's a couple rules that are very important. And you miss any of this, your planning is out the door. It's not going to work. The trust, number one, cannot be revocable. It has to be irrevocable, meaning that once the ink dries, you're locked into it. It can be income. It has to be income only to the grantor. And this is what I mean by that. If I put my money in my irrevocable Medicaid trust, I cannot take that money out. The only thing that I can take out is the income earned by that money. So I put $100,000 in, it's earning 5% at the bank. I get to take out the $5,000 of interest in that year, but I cannot touch the $100,000. That's off limits. It'd be too easy. If I could touch it, if I could use that money, or if my kids could take it out and spend it for me, it's too big of a loophole. So the government shut that one down a long time ago. And the other thing here is subject to the 5 year look back. And most people are familiar with the 5 year look back. And it says that, if I transfer the assets, I don't qualify for Medicaid for 5 years from that transfer, as long as 5 years. So think about it this way. I set the trust up. If I apply for Medicaid within that 5 year period, I have to disclose the trust assets as being still belonging to me, even though I transferred the assets to an irrevocable trust. For Medicaid purposes, it's still counted against me. But if I make it to that 5 year period, that 5 year clock runs on me, and now I'm beyond 5 years from the date of transfer, I don't have to, that the money in the trust is no longer considered mine. So now I can potentially qualify for Medicaid. This planning, one thing, it's very important to be really comfortable with your financial planning side of this. In other words, if I put my assets in an irrevocable trust and the assets have to stay there for 5 years, I need to figure out what I'm going to live on for 5 years. So in an ideal, perfect set scenario, I figure out what my costs of living are going to be for the next 5 years, and I don't put that in the trust. I live on that money. I put everything else in the irrevocable trust. And at the end of 5 years, if everything works out fine, then the money my 5 year living expenses are gone. And the money that I put in the irrevocable trust are protected. Doesn't always work like that, but that's the ideal scenario. Okay. Talked about, last 25 minutes or so, talked about a lot of different things. Touched on a few items that I think are really important for estate planning. The importance of a will. It gives you the ability to control where your assets go and control who's going to be in charge of that process. Durable power of attorney, very important document. That's for financial decisions if you become incapacitated. And the healthcare proxy. Similar situation, except for medical decisions. If you can't communicate with your doctor, you want to make sure that someone has the authority to make decisions for you. Talked about the importance of a trust. The revocable trust, the one that I'm in charge of and I can make changes to anytime, versus the irrevocable trust that's more common in the Medicaid planning context. So the irrevocable trust, once I put the assets in there, very limited, extremely limited what my benefits are on those assets. Big difference between the revocable versus the irrevocable. And then on the slide here, I've got, just places where if you're looking for more research or more information on the topics that we covered today, here's some resources for you. And finally, so I practice in Massachusetts. The estate planning is really state specific. If you're out of state, if you're not in Massachusetts, or actually if you're anywhere, you want to have an attorney who's experienced in this area, who is licensed to practice in that state, because most items, most issues, most legal issues transfer from state to state, but not every legal issue will. So make sure you have someone local who's helping you out here.